In South Africa, we currently have the Copyright Act 98 of 1978 and the Performers Protection Act 11 of 1967. Copyright law in South Africa is said to be not up to date with our modern society. It was last amended in 2002, and it is widely acknowledged that it needs to be amended to sufficiently protect the works of artists, creators, and performers. The purpose of this slide is to give you a basic introduction to see how new laws are passed in South Africa. A bill is a draft version of a law. As you can see, it is not a simple process. It takes a long time and has to get through a series of avenues before it is eventually signed by the President, as you can see by the last step. Once it is signed by the President, it becomes a law. As I've indicated with the arrow on the slide, the Copyright Amendment Bill is currently at step 5 of the process. It has been tabled for a second reading, which means it will be debated in the second house and then voted on. If the majority of the National Assembly votes in favor of the bill, it will be passed provided it is signed into the law by the President. In June of 2020, President Cyril Ramaphosa rejected the Copyright Amendment Bill and the Performers Protection Amendment Bill for a variety of reasons, most of them being technical reasons, so I'm not going to go too much into detail with them. We cannot be sure how long it will take for the bills to eventually be passed, and we therefore cannot yet rely on the protections that they might or might not offer. However, what art students can take from this is that they can be glad to know that a lot of collaborative work and research is being done to ensure that new protective copyright law is passed in South Africa. Based on my research done of the Copyright Amendment Bill, I found a few relevant clauses that I think are most relevant for artists. The first one is Clause 6 of the Copyright Amendment Bill, public distribution. What this means is that, under the Copyright Act, Section 7 stipulates that having copyright over artistic works means that only the artist or the person authorized by the artist may reproduce, publish, adapt, etc. the piece of work. The Amendment Bill therefore includes the act of distributing the work to the public via the Internet. To give you an example of this, a person who distributes your art via the Internet over WhatsApp, Messenger, Facebook, or any other public platform would not be allowed to do so unless they have your permission. Clause 7 of the Copyright Amendment Bill includes the right to share in royalties on commercial resale of your work. To give you an example of this, an artist paints a painting named The River. The artist then sells the river to a small business that sells mugs. The small business then reproduces the painting onto mugs and sells those mugs to the public. As the artist, you would be entitled to resale royalty rights on the sales of those mugs. Clause 24 relates to orphaned works. Orphaned works, in terms of the definition given by the Copyright Amendment Bill, are works that cannot be identified or the author of those works cannot be located. What this means is that if you were to find a painting, for example, at your local charity shop that does not have the artist's name on it, or any indication of who it might belong to, you would be permitted to apply for a license over that copyrighted work. Clause 36 of the Copyright Amendment Bill seeks to include audiovisual work. This means that if an artist would create an art on a device, it would be eligible for copyright. The art would need to consist of moving images and be played, perceived, communicated through a device to qualify as audiovisual work, and it would therefore be copyright protected. An example of audiovisual work would be a short film with or without sound that is played through an iPad. That short film would therefore qualify for copyright, provided it meets all the other requirements under the Copyright Amendment Bill. The final clause, which I think is most important for artists, is Clause 12, Fair Use. The Copyright Amendment Bill introduces fair use as a defense instead of fair dealing, which currently stands in the Copyright Act. Fair use is a far wider defense than fair dealing. To give you an example, an artist creates a detailed sculpture of the internal human anatomy. Any person could use your work for purposes of criticism, reporting, commenting, researching, teaching, or any other reason, provided it is considered fair. An example of the use of that work would be a biology teacher using the sculpture to teach his or her class, or a reporter using the work to report on the types of works created at a particular institution. As an artist of that sculpture, you would not receive any royalties for the use of your work, and the person using it would not need to obtain your permission. This means that if you are unhappy about someone using your work, you would have to approach the Copyright Tribunal. The tribunal will determine whether or not the use of your work is considered to be fair or not. This would most likely be a timeless endeavor. There are 4 factors or criteria that the tribunal will use to determine whether or not the use of the work is fair. The factors are as follows: the purpose and character of the use, the nature of the copyrighted work, the amount and sustainability of the portion used, and the effect upon the rights holder's potential market. As the Copyright Amendment Bill refers to factors, this means that ultimately the decision is in the hands of the tribunal or the court. A single factor would not be determinate, and the decision maker would look at all the surrounding circumstances holistically and take all the factors into consideration before making their decision. To conclude this presentation, I have just set out some benefits that the Copyright Amendment Bill poses. It aims to promote the progress of science, innovation, and useful creative activities. It deals with the protection of works and rights of authors in the digital environment. It provides for availability of accessible format copies of work to accommodate people with disabilities. It introduces a resale royalty right. Artists could be entitled to a royalty even when their original work is resold commercially, as discussed. It also provides for a strengthened copyright tribunal, and there are technological protection measures to reduce incidents of copyright infringement.